Hello to all of those that are joining us for this webinar. I'm just going to give it a few seconds as people come in from the waiting room. My name is Barbara Armstrong from MSD UK. So we will start in just a few seconds. I can see that the participant numbers are just going up as you come in from the waiting room. So 10 seconds and we'll start with introducing our speaker today. Okay, because there's some valuable stuff that we need to get through today. So without any further ado, I'm really delighted to be able to introduce our presenter, our speaker for today, Rina from Longmores Solicitors. She is an expert in IP, commercial contracts, and generally just fantastic knowledge on business. So it's going to be a session about generating revenue from your IP assets. So without further ado, I will now hand over to Rina to be able to continue this session. Rina, over to you.
Thank you, Barbara. Good afternoon, everyone. So we're going to be talking about generating revenue from your IP assets today. What I would start off by saying is that most IP is worthless unless you are actually doing something with it. And the key is to ensuring that you've got a viable offering, and that could be a product or a service or a combination of the two, and devising a strategy on how best to commercialize or exploit your IP so that it generates one or more multiple revenue streams for the business. I mean, ultimately that's what you're there for. So there's lots of different ways to do that, and so during this Power Talk session I'll be running through the key ways for businesses to exploit their IP, and I'll also evaluate some of the pros and cons of each of those options, because some ways might be better than others depending on a whole range of factors, and we'll talk about those. It's intended to be quite a short Power Talk, so I'll try and keep within the time. If we do run out of time, and if we don't manage to answer any sort of questions at the end of this slot, then do come and find me in the Longmores virtual booth. I'll be in that area for sort of a good hour or so after this talk. So if you do want to ask any questions, then do come and find me in that area. Alternatively, do reach out and connect with me on LinkedIn. Happy to have an offline sort of chat with you after today's event. So getting straight into this and moving on to the first slide, it's obviously first important to understand what IP is and what IP you've actually got in your business. It can be seen as a driver of value. It protects innovation and growth. It builds goodwill by enhancing your reputation and building your customer loyalty. IP can prevent the unlawful use of your work, and importantly, it can attract investment, which is key to any growing business. Ultimately, it gives you an economic and strategic advantage and a competitive edge, so it's really important. IP rights can exist in everything pretty much, from photos, software, research reports and methods, databases, designs, manufacturing processes, pieces of music, software, games, consumer brands, in all sorts of industries. So it's really quite a global sort of broad range of intellectual assets, which can be exploited, as I say, for commercial gain. This slide shows all of the main forms of IP, and I'll have a really quick skim through, just spending a few minutes on each of these rights of IP, because it's really important to understand what they each do. So moving on to the next slide, looking at patents, first of all, patents are obviously granted to owners of new or enhanced innovations. They've got to be completely new and novel, and they cover how things work, what they do, what they're made of, how they're made, and can be a product or process, and protection can basically last for up to 20 years. Great examples would be, the Dyson Hoovers. It could be patents around medtech, biotech, pharmaceuticals, telecoms, electrical apparatus. I think one of the biggest electronics corporations in I think it's the UK actually, last year filed over 5,000 patents, and that was Huawei. And that was closely followed by Samsung. So, patent protection is invaluable, particularly for those larger organizations, but also for the small startups that have got something really unique that they want to protect. It can also be applicable over software in some cases, as long as there is some sort of innovation and a technical effect, although the UK doesn't particularly like patents over software, and each case will be viewed on its own merits to see whether you could get a patent over software in particular. Trademarks used for brand identity, they basically distinguish between your goods and services compared to your competitors. They can be words or logos, as examples on the slide there. They can be slogans, they can be sounds, they can be colours, such as the Cadbury's purple, the BP green are registered. Protection lasts potentially forever. Trademarks are renewed every 10 years. With both patents and trademarks, they're territorial rights, so you've got to register in the countries that you want the protection. It's really important to look at other countries other than the UK as well if you're looking to branch out and expand your market overseas. Turning to the next slide, design rights protect a product's visual appearance. This can be for the whole or part of a product and can entail colours, shapes, texture, and again grants exclusive rights to the owner for a limited period, usually around 25 years. We've got these rights registered to use, make and sell any article that these designs are applied to. And again, we've got examples on the slide there. It could apply to things like book or video game characters, such as Lara Croft. It can apply to furniture and household items, surface patterns, all sorts of things. Copyright is a right that arises automatically, very relevant to most businesses out there. Protects original work that you develop and which has involved some skill, labour and judgment. And that could be literary work, it could be dramatic, musical, artistic. It can include sound recordings, films, broadcasts. For businesses, examples of copyright protection can exist in films, books, source code, business plans, documents, website copy, photos, and so on. And in most cases, the copyright will arise and last for around 70 years after the death of the creator of that copyright work. So again, it gives you great sort of protection. A recent development with copyright is that WIPO, the Worldwide Intellectual Property Office, has just recently launched a new service to help create a digital footprint. And basically, this acts as an independent record which verifies and provides evidence that you owned a particular bit of work and it was created on a particular date and time, so it sort of date stamps it. And that can be really valuable if you're ever criticised or somebody else comes along and tries to say that you've infringed their copyright. It's a great defence mechanism. A good way of protecting a copyright is also just to keep and date records and early drafts of documents that you've created. You can include watermarks or comments in electronic image files. In software, it's quite common for businesses to include footprints, which will be things like deliberate mistakes in the source code, so that if it is copied, you can point out and show the mistake and the fact that that is there to prove that it is yours and in terms of ownership, rather than somebody else's that may have just copied your code. So that's quite an important right for most businesses. Moving on to the next slide, you've also then got you've got trade secrets, confidential information, know-how or sort of knowledge, and that's a general kind of pot of all sorts of useful commercial information which can be sensitive. And again, this is normally quite useful for most businesses because it will protect those elements that can't always be protected by a registered IP right. Great examples on this slide. One that I discovered drinking a glass of Pimm's this summer was the fact that, you know, even on the bottle it says that it's made from a closely guarded secret recipe. And all of these examples show that you know, you don't have to divulge the exact ingredients or formulation of what you've created, and that is what helps to protect against competitors copying your sort of secret recipe or your particular sort of formulation. There are other rights of IP, other forms of IP rights too. That could be things like database rights, plant variety rights, even domain names are sometimes seen as IP rights because they protect a particular website address for you. And also social media usernames as well is sort of following the same line on that. Moving on to the next slide, and before I go on to the pros and cons and the different ways of commercialising your IP, as I said, what's really important to note is you've got to think strategically about what you've got, because the IP rights on their own will only get you so far. And that's because you've got to do something with the IP to actually add value and start generating money for the business. In other words, it's not what you have, but it's what you do with it that counts. And I'm sure I've heard that somewhere before, but anyway. So what can you do with your IP? You can commercially exploit it and use it to generate income, which can be done through a variety of ways. The first of these is where you're looking at developing the IP yourself, or direct exploitation. Essentially, with any IP strategy, it's got to fit with your overall business plan. And so this is a great way of doing it all yourself. It's basically where you develop your IP into a tangible product or service that you make and sell yourself. The process that's normally involved with this is where you take an idea, you then do some R&D research and develop and make sure it's a viable sort of product. You do some testing, you sort of get that sort of proof of concept under your belt, and then you can start going out to then really start rolling out what you've developed. And if it's a product, you then go through manufacturing process and start selling. This option has got the highest risk, but it also reaps the highest reward, because essentially you get to keep the profits once you've deducted all expenses and operating costs. And also you can claim the associated tax reliefs as well, which can be really generous, especially the research and development side of things. So do look into that if you're going down this route. The disadvantages is obviously that it takes a lot of time. You've got to invest a lot of time, money, people in doing it yourself, which can be risky. And particularly considering the fact that the majority of businesses fail in the first 2 years, and the statistics show all of that. And so, you know, you may decide that if you don't have that time or the right skills and it's an unattractive option, then it could be that this particular route of exploitation isn't for you. Great examples of this sort of a path have been trunky suitcases for kids to sit on and their sort of luggage. You can possibly see a small picture of my twin boys up on the wall behind me when they were little. I had these 2 trunky suitcases for them, and they were invaluable. They were ingenious at the time. And the inventor of these cases basically went on to Dragon's Den, failed to win investment, but then went off and developed it himself. And you can see from, you know, reading the stories in the press about his business story how successful that's been doing it himself, and he's diversified into other product lines and so on since. So it can be a really good strategy. Another example is Levi Roots with his reggae sauce. Again, he was on Dragon's Den. He's now expanded his sauce into supermarket chains, and then he's also diversified by doing his own thing by publishing a cookbook. I think he even got a music album out, started getting organised with a Caribbean-inspired food festival, and has had his own TV cooking show, restaurant chain. There's kind of, the opportunities are endless once you've got a set of IP rights that you own. You can really kind of do a lot with it. The next form of exploiting or commercializing your IP on the next slide is where you sell the IP. Now, this is basically where you permanently transfer the ownership and rights that you've got in the IP that you've created to a third party for an agreed price. It can be a good option when your business doesn't need the IP, and it's a quick way of raising revenue. And the usual way in which you would normally sell the IP is through what's called a written assignment, which is essentially a transfer. It's got to be done in writing. If you think of having a box in the attic filled with all your unused IP and great ideas that you haven't developed, or you just don't have the time resources to develop, this can be a great source of revenue for your business, is selling off and looking at what could be valuable to somebody else, and selling it. You might not have the time, resources, or inclination to use that IP, but you could still make money from it by getting somebody else to do the hard work, and you'll at least get something for that IP rather than it sitting there. The difficulties of that, though, of this option, that it can be quite difficult, I think, to set a fair price for the sale, because if the IP hasn't been commercialised, then it can be quite tricky to know how much money it could make, and how valuable it is, which is obviously a risk for both parties. But it's just trying to look at what the potential opportunities and scope of the IP could be and the potential market could be. So that's kind of the downside, really. And obviously, you're losing control of the brand, and once you sell it, that's it. It's gone forever. You don't reap any further rewards in future. You wouldn't get royalties or anything like that. And you could potentially lose out if the product or service does go on to become really successful. Once you sell it, that's it pretty much in terms of your input and reward. It can be a great option for people who have sort of, who are ideas people, but don't like or haven't got the time or don't want to invest the time in the delivery or the execution of kind of carrying out the idea. I had a recent client who had two great ideas in relation to the luggage industry, and essentially he came to me because he was looking to patent them and then looking to sell them to manufacturers, sell those patents, that is, so that he could then move on to the next idea. And he realised that those manufacturers would be able to have the scope and the resources to be able, and the contacts to be able to sell those ideas into the luggage industry. But he wasn't so concerned with the rest of the process. He just wanted to get some money for the patents and move on to the next thing. So it's great for that type of approach if ideas are your sort of strengths and the execution maybe not so much. Now, moving on to the next slide, this is the most popular way of exploiting your IP, and you can see it day in, day out, everywhere you turn. This is basically licensing, which is where you continue to own the IP, but you're essentially giving permission to third parties to use and exploit that IP, usually in return for a royalty based on the sales that that IP generates. That can be through a marketing arrangement. It could be where you appoint sales agents, where you're setting up a distribution network, all sorts of different ways of doing this. As I mentioned, you get to continue to own the IP and receive royalties. So it's great for that option where you continue to just hold it, but not have to do all the time and effort of actually going out and selling, particularly to different markets or territories. So in that sense, it's a great marketing tool by using other people's time and resources, because they do the hard work. You receive a percentage of their hard work. It's also great for increasing brand awareness and increasing sales, particularly in other markets or countries that can benefit, especially. And again, you get the IP back at the end of it, which is great because you continue to own it throughout that whole period. The downside is that you've got to then spend a lot of time and effort getting the right licensees and going about doing the due diligence to find the right sort of licensing partners. And there's also some initial expense in getting a license contract or agreement into place, because you want to make sure that's clear, particularly in terms of ownership of the IP, what they can and can't do with it, because essentially you're giving away IP or potential information to potential competitors. So it's vital that you get a contract in place for that. You can use licensing in all sorts of ways to make money, and this could involve discovering new forms, markets, or even bundling it with other IP outside of the core product or service. For example, you could get a copyrighted rock and roll song, which could contain lyrics and rhythms that work well for a TV advertisement for, say, a motorcycle company. There's all sorts of things you could possibly do or apply. And savvy IP owners are finding new sources of income by repurposing their IP and using it in a different industry, which could be completely non-competing in terms of the field or the product application. So it's really important to think laterally about what you could do. I mean, there are some great historical examples of where that sort of happened, including, bubble wrap. That first started off and was originally invented as wallpaper, believe it or not. And so, it just really does pay to think about other uses for the IP that you develop. One further example before I move on is a company. I've got an investor contact, a friend, and he basically worked and invested in a company that developed a product for assisting patients who develop deep vein thrombosis or DVT on airlines. The company realised that only a very low number of people die from DVT on flights each year, so it made it really not a viable product. However, the company changed its strategy to healthcare when they realised that large numbers of patients suffered from DVT when they were recovering from surgery. And so the company suddenly had a viable product. So that helped diversify it into a different market. And then later there were some rugby clubs that realised that this sort of product, this could help in a sports capacity to help their players recover more quickly. And so the company created a completely new brand, repackaged the product and started marketing it and selling it to sports clubs too. So, you could repackage, rebrand your offering completely, look at what you've got and the uses that it could be made of it in other fields beyond what you have originally developed it for, because that can work very successfully in some cases. So it's about exploiting your IP for multiple purposes. You could even do it with professional know-how, by licensing, the rights to a brand name and a suite of, for example, proprietary online consulting tools, say, and using it to, in other countries under a packaged sort of solution. You can do it as you can also have an option where you do white label branding, and the next slide sort of shows some of these options that I've talked about. But you could potentially have something that you've created and decide to offer it as a white label sort of a product to other big brands who can put their branding on it. So you provide the back end solution and then they pay you for being able to use that, but put their own branding on it. Some of the supermarkets do that, an amazing job of that with consumables, but they use white labeling all the time by sort of private labeling their own product ranges. So you've got like Sainsbury's Finest ranges and things like that. And they tend to be more cheaper than the sort of the proper, more established brands in that sense as well. So they really do make use of that opportunity. Another form of licensing is franchising, which is worth mentioning. Basically, it's a form of licensing, but together with a system of how to sell. So it involves sort of an established brand proposition and a license of the trademarks, the know-how, the copyright in any sort of manuals. It can include things like product packaging, staff uniforms, signage, marketing materials, and so on as well. So that's a sort of an extension of licensing, sort of a bit more packaged up. And again, I've worked with big brands such as Subways, Domino's, Specsavers, coaching businesses. There's all sorts of, again, industries that can use the franchise model very successfully. Going on to joint ventures and collaborations. So if you're combining your pool and pooling your skills, resources, costs with a third party, you can really help to reap the rewards and share the benefits with that party. So it's great if you haven't got the skills and resources, but somebody else has, and you can combine forces, form a joint venture. Sometimes people form a joint venture separate company that they each own half of, and it just helps reduce the fixed costs and allows that sharing of everyone's expertise and IP. Disadvantage of obviously doing that is if parties fall out. You've got to have, again, really clear contracts put into place which says what would happen in terms of existing ownership of IP and any new IP that's developed between two parties in this sort of a collaboration mode. So it's really important to get clear contracts, because there's all sorts of disputes I've seen over the years that could result in the absence of having sort of clear agreements in place about joint ownership, or what happens if somebody wants to terminate or exit that agreement. Moving on to sponsorship. So the next slide, sponsorship will often be through spin-outs from universities, or it could be through other third parties, through sponsored R&D activities. It takes various forms, but it's essentially where an organisation will pay you or provide you with some sort of a grant for researching a particular area. So there's less cost coming out of your own pocket, which is great. The downside of that is that often the academic institution or the R&D company or the university will want to retain as part ownership at least of the IP, but license it or provide permission for you to use it. And sometimes you need to share some sort of revenue off the back of the IP with the institution that's provided that sponsorship to begin with. So it can be great for funding up front, but you do need to carefully agree the terms and negotiate the terms with that organisation to make sure that you're still getting a good deal of it out of it at the end of it. With any of these ventures where you are working with third parties, it's really important to do your market research and due diligence in finding the right partner or licensee, and check their background, their track record, finances, check they actually own the IP that they're saying that they have, and so on. So that's most of the forms of exploitation in a nutshell. It's been a very quick run through. The next slide shows all of those just that I've gone through, and there are other forms of exploitation as well. I mean, you can exploit your IP and use it in relation to security for borrowing finances, or in a sort of a corporate finance sort of a deal. Usually that could take a mortgage or a charge over your IP assets, but it can be quite tricky going down that path because it's, again, difficult to sometimes value the IP that you've actually got. So as we've seen, there's a number of ways to make the most of your IP and really use it to help grow your business and your bottom line. Deciding on which commercializing method to use will depend on a variety of things, including your business objectives, the forms of IP that you've got available, your skills and financial resources, the market in which you operate, your strategy, your short-term versus long-term goals, your attitude to risk, and any investor preferences and so on. Whichever route you choose, make sure you get properly drafted contracts in place, protect your IP, how it can be used. I hope today's session has given you food for thought. Should you need any help with any IP strategy or contracts following the session, do feel free to contact me, connect on LinkedIn. And as I say, run out of time for questions now, but if you would like to come and find me in the virtual booth for Longmores after this talk, I'm happy to answer any questions that you might have. That's all for today. Thank you for your time. Speak to you soon. Take care.
Thank you very much for that, Rina. That was absolutely brilliant. It really covered all the key points that everybody is asking. There are a couple of questions, but I've suggested, as you say, that they come and visit in the booth or contact you separately to this. But that was brilliant. Thank you so very much. And thank you all for attending. Thank you.
That's fine. That's great.
Bye-bye,
Thank you so much for your time. Take care all.
Thank you. Bye-bye.